A very good afternoon to all of you. Very pleased to be here. And Alan, thank you for a very generous introduction. Let me just add to 2 points which Alan introduced me, because it's relevant to this issue that we're going to discuss. We have worked in over 25 developing countries in evolution of new competition law in very difficult circumstances, if you remember. In fact, I remember I was talking to Mark when I was here in this law school. There was a seminar that we were attending, and people felt that the internationalization of competition policy was thwarted by the WTO, when in fact I had pointed out that competition policy was one of the 4 issues of what was called the Singapore issues. And so competition policy became a victim to the politics of WTO rather than a per se victimization of, which is also to echo what Alan introduced us. I mean, we do a lot of work on trade policy as well. Twice I have served as advisor to the WTO Director General. So that brings in fact, our work in the area of competition policy was actually sort of situated in 1990s when countries were liberalizing, including India, which were otherwise mostly inspired in the developing world. Most countries were inspired by the Russian model or the Soviet model, I would use the more precise word, of central planning and control. And therefore, when people felt that at that point of time that you did not need any competition regulation as far as you could allocate the various factors of production, competition would not be required. I mean, that's the kind of background which is what I was talking about. And when we realized that once we have started liberalizing economies, then you require market regulations in place. You're becoming a market economy without market regulations, of which competition policy was one of the most important ones. I mean, other than sector regulations, as was also pointed out. Now, it is not as if many developing countries did not have a competition law even before adopting these economic reforms or turning into a market economy. Few of them, I mean India, Pakistan, in South Asian region, Kenya, South Africa and Africa, had a sort of competition law sense which was mainly modeled on the 1998 British Competition Act, mainly looking at control of monopolies and monopolistic practices rather than restrictive business practices or cartels and stuff like this. I mean, that was the main thrust at that point of time. And all these countries have since then adopted new laws. And India was one of them. The first law that we had was the Monopolies and Restricted Trade Practices Act, named after the British law at that point of time, 1969, which actually came into being after an inquiry launched by the government through 3 different committees to look at the kind of concentration of economic power and the kind of competition scenario. Let me give you an example. Many of you may not know, but in the good old days, there was a cosmetic, perhaps the old ladies would know. So call it face snow, and not a face cream. You might remember, in the good old days, we used to get this cosmetic called face snow. So, particularly in the where you had darker skins, I suppose that people looked at how they could look whiter and so on. The point what I'm trying to say that the inquiry committee report also found that there was concentration in the market for face snow. There was only one producer, and producer could. I'll just give you an example of something which could be as ludicrous as a very simple cosmetic. And mind you, I mean, most of these developing countries, including India, followed a mixed economy approach. There may be 20 to 25% of the GDP in the hands of the private sector, but by and large, the major amount of economic activity in terms of manufacturing or services being in the public sector. If you look at electricity, telephones, these huge services are all in the public sector. And in 1991, in 1990s, most of the developing countries adopted reforms for various reasons. It could have been external pressures in some cases, or it could be an internal realization, or it could be a combination of both. If you might have heard about in the 1990s, most of the African countries had to undergo what I call the structural adjustment program, pushed by the multilateral development institutions, multilateral lending institutions like the World Bank and the IMF. India also was in a similar kind of situation. It was due to profligacy. The foreign exchange reserves had come down to very poor, very low levels. In many countries, they even went to the negative levels at a point of time. You see, you could only finance about hardly 7 days or 10 days of our import bill. That was the kind of situation in 1989, 1990. So 91, major amount of reforms were adopted. The foreign exchange regulations were changed. Import tariffs were brought down, and many other things happened, which included the then MRTP Act, the Monopolies and Restricted Trade Practices Act. A couple of changes which happened, structural changes in the MRTP Act was, number one is government enterprises were exempt from it, as has happened in many countries, even when they brought in their new competition law. Under the kind of thinking that the king can do no wrong, and therefore, public enterprises are there to serve public welfare. Therefore, they don't need to be subject to any competition regulation. Number one. Number two is merger regulations, which existed in the old Act, were diluted in the sense that, now that you have to enter into a global economy, we need our enterprises to become bigger. And therefore, these merger regulations can be counterproductive. There are two major changes which took place in 1991 amendment to the MRTP Act to reflect basically from the kind of structural changes which are taking place globally as well as in India itself and in many other developing countries. Now, the Act drew its legitimacy from the constitutional provision of that the state is required to check the concentration of economic power, which still exists in our constitution in spite of the fact that we now have a Competition Act which doesn't actually follow that principle. Now, as I said, that was the scenario at that point of time in 1990s. We could not even get a telephone line connection. Couldn't get a cooking gas cylinder, and so on and so forth. Things were in a very bad shape. As it happened even in, you might have heard about various other economies as well. I think at that point of time, even the telecom sector in Australia was still in the public sector. Even the Australian privatization of the telecom sector underwent a lot of debate. I still remember that. But just to give you an example of how the things in terms of economic governance were changing globally. And in a country like India, which was well steeped in kind of very left thinking, politics, that you did not allow things to happen so easily. So what did happen in India is, in many areas, rather than privatization, they opened up the sector to competition, allowing private players to come in. And in the teaching phase, the time when I'll give you a very ludicrous example. The airline sector, civil aviation was opened up. And I don't know if you know, there's a province called West Bengal in India, which is half of what Bangladesh is. Used to be the same province at one time before independence in 1947. It has been having a democratically left government, a communist government for many years, no longer now. So when the private airlines came to the operation, the trade union movement in Calcutta, of the bastion of communism, came out to the runway to block any private aircraft from landing. I mean, that's the kind of ludicrous opposition in protest that they could, In spite of not understanding that by introducing competition, you're going to improve the state airline as well, which incidentally continues to operate at the cost of the taxpayer, has been running into losses. But I just gave you that very another ludicrous example to show you as to how things were changing and how difficult it was socially in many cases to agree to those changes. So, as a policy, what the government of India did was, in very few cases there was privatization. And the major one that I remember is a bread factory which was privatized. But otherwise, in all service sectors, electricity, railways, I beg your pardon, not railways. Railways still continues to remain in the public sector, except for some operations of railways have been privatized or opened up to competition. So the overall, the political philosophy which was followed by Government of India is that you will subject all the public enterprises to competition, which were otherwise, as I said earlier, exempted from the MRTP Act, and allow them to face competition. So once the competition came into being, whether it was the state insurance company or the state airline, they started behaving far better than treating the consumer like a doormat, which they often did. Because of the fact that, complacency, there was no choice the consumer had. Television also. I mean, every possible sector was opened up to competition, and private enterprise was allowed to enter, and therefore it became more and more necessary. And that is the argument we took before the Government of India, that the Monopolies and Restricted Trade Practices Act is an arcane act, is an ancient law. It is not going to help to regulate. It had no penalizing powers also. It could only order cease and desist. Okay, you've been caught carnivalizing, please stop doing it. Okay, we'll not do it. We'll continue to do it in one manner or the other. It also had what was called the unfair trade practices provision, as the Australian law has, on misleading advertising and deceptive claims, which the new competition law doesn't have. I'll come back to that later. And that is the time we argued before the government that we require a new competition law which will be able to deal with all this, including have penalizing powers of penalty. Otherwise, you'll not be able to prevent anti-competitive practices happening just on the just with the kind of order you pass is that you get the perpetrators to give an undertaking that we will not do it again. So what we continue to do it. Now, the second part of my presentation is on that. So this is the kind of introduction and background to give you a taste of what was the background we were coming from. And as I said, there were a shift at that point of time was from, as I said, from a closed economy to an open economy, a market economy, which included the kind of understanding that the government will continue to operate in many sectors, but open it up to competition for private investment to come in, which helped the state-owned companies also, because they also then became alive to competition as well as better consumer response. Now, a question which has often been asked is, and as Alan said in his introduction, we were fairly influential in our country in the sense that we could talk to politicians about all this and get things moving. So it was the consumer movement which was basically the main sort of demander for change in this particular law. Including, by the time the realization had already happened, as I said, many of the service sector was being liberalized, telecom, electricity, insurance. So they brought in sector regulators inside, and all the sector regulators, one of the objects of every sector regulator was to promote competition and consumer interest in that particular sector. The Electricity Act even went to the extent of allowing the electricity regulator to deal with anti-competitive practices, though it has never dealt with it. But that's another major issue. So things were changing, and at that point of time, our argument before the Parliament and the government was that we require a new competition law, as has been already happening. And quite naturally, as we have seen in many developing countries, including in India, as the first opposition comes from the business. Why do we need a new law? Why do we need a competition law? Including from some very right-wing economists who believe that liberalizing trade is a sufficient condition to prevent anti-competitive practices. And despite our argument that, look, trade liberalization is happening, but is it preventing these kind of anti-competitive practices? It is not. Cartelizing, for example, abuse of dominance, for example, and so many other things. And the government finally understood this. So what we agreed was, the government of India, is that they will bring in a new competition law which will be implemented in phases. Fair enough. I mean, that was one argument made by the businesses that let's move slowly. There's a very good Latin expression in that, I forget, but let's not hasten these processes, any change. One can understand, in any governance situation, if you are going to bring about any change, any radical change will produce very negative outcomes, as has happened in Russia, as everybody knows about it. Now, so it would be a phased-in. First stage would be advocacy. The second stage would be vertical and horizontal restraints, and finally merger regulation. So in 3 phases to make the business feel comfortable. And even on merger regulation, we said we will have a soft-handed approach. This is what the Commission would do, as a philosophy of the government to guide the Commission that, look, you cannot deal with mergers in a way that you would have dealt with in the past. What would be the relevant market, what would be and that has to be looked at. You have, the whole world is now an integrated market. So how do you deal with that? Now, fortunately, you could get the business around to agree to these changes, and so slowly it took place. But something very funny happened, and this is what I and Mark were talking about a little while ago, about the institutional processes. The MRTP Commission was headed by a retired judge of the High Court of India, any High Court of India. The Competition Commission, which was established, they appointed a retired bureaucrat as the head. And that was challenged in a public interest litigation before the Supreme Court by a public interested lawyer. He said, look, how can you have a retired bureaucrat to run a quasi-judicial body? And the Supreme Court held it under what is called the doctrine of separation of powers between the judiciary and the executive, which I'm sure all of you know what it is. And for nearly 5 years, the Competition Act could not come into being, though it was there on the statute book. So for 5 years, there was a skeletal commission appointed with one member and a chairman who never joined, and a small staff. So they to do advocacy, education, awareness, etc. So that is what they did. And one of the suggestions we had made to the government of India even earlier, during the hearing of there was a committee which was set up to look at this introduction of the competition law, that you should have either a bilateral kind of body, a competition commission with a tribunal, or a South African model, which is probably unique in the world, where you have a competition commissioner, which is basically a one-person prosecutorial, investigative and prosecutorial body, competition tribunal, and then an appellate bench in the High Court of South Africa, a dedicated appellate bench, which is quite rare. I mean, normally you don't get this kind of thing in the common law world also. So finally there was a kind of trade-off between the government and the Supreme Court, and we'll have an appellate tribunal headed by a retired Supreme Court judge, and the Competition Commission headed by a retired expert, as we call it. Now, whether they were experts or not, that's another point. None of them were experts. I mean, they all learned on the job. They were all very smart bureaucrats, smart civil servants who could learn But I dare say that it was, the debate, as I wrote also, was the tragedy is you are talking about a retired judge and a retired bureaucrat. You're not looking at an active judge or an active bureaucrat. Now, an active judge would not like to take this kind of job, a tribunal job. He would like to remain in the mainstream judiciary, which is much more powerful, much more prestigious, and so on. So that is how it was. So, by and large, if you look at the kind of problem which arose, so once the Government of India moved a Competition Amendment Act in 2007, 2002 was the law, Competition Act 2002, but 2006-07 the amendment was approved, and so now you have two bodies, a Competition Appellate Tribunal and a Competition Commission. A Competition Appellate Tribunal to be headed by a retired Supreme Court judge with two members from any profession, and a Competition Commission headed by a chairman with 6 members from any profession. And usually all of these were retired civil servants, not even, no lawyer worth his salt would take up these kind of jobs. Any of them. The salary was very poor, government salaries and so on. And secondly, the kind of independence which is required for these bodies to work effectively, particularly the Competition Commission, not the tribunal. The tribunal being headed by a retired Supreme Court judge would be independent, would be quite sort of strong in terms of its independence as a matter of the political philosophy of judiciary as such. But the commission particularly, so usually you had, in many cases there were time servers, the members. Some of them were good. It all depended upon as to how the chairman. Now, the institutional issues in the adoption of a new law can be reflected from many of these points which I have just made. The peculiarities in the context of India itself. That we have a very powerful bureaucracy which runs the country, which therefore not only Competition Commission but every possible regulator is manned by a retired bureaucrat. And similarly, we had the information commissions and the consumer dispute redressal commissions. All are populated by retired bureaucrats. They have a very nice cartel among themselves to capture these positions, presuming that they are the best who can do. So, in that situation, how does the competition law regime evolve? I would say fairly well. in spite of whatever fears there might have been, in contrast to certain sector regulator, but there were other problems in terms of overlap between a sector regulator and the competition authority, which is still to be resolved in India. There are provisions in the Competition Act that they may be consulted by other sector regulators, but it's an option. In very few cases have they been consulted. I'll give you an example. There was a cartel of fuel supply companies, which were mainly state, and two of them were private sector. That was challenged by the state airline before the competition authority. The oil companies went to the Delhi High Court, which is one of our best high courts in India, and got a stay on the case before the Competition Commission that it is the Petroleum and Natural Gas Regulatory Board which can deal with this issue. Because the PNGRB Act, as I told you a little while ago in its introduction, in its object says it is there to promote competition and consumer interest. It doesn't explicitly say that it is required to check anti-competitive practices, the way I told you Electricity Act does, though they have never used it. And that matter is still pending in the Delhi High Court. And getting this kind of overlap sorted out between one regulator and the other regulator is something which is still sort of work in progress, still not yet been settled. What we are trying to do with the government is that make it mandatory, as it happens in the case of in Europe, for example. It is mandatory. I don't know what is the situation in Australia. Perhaps. Now, one very important institutional challenge. The other institutional challenge, and this is this is the last chapter of my presentation, is how to build capacity in the Competition Commission, because mostly because of the salary issue, the kind of compensation which is paid, you only get secondments from other ministries. They are not able to get fresh candidates who would come and think of making a career there because the salary levels are very low. I mean, they would make much more in a law firm rather than to come and work, or an economics consulting house rather than to come and work in the Competition Commission. Except, as I said, in the case of, we do get some non-governmental people, but from universities, academics, who would then, also work for the Competition Commission for a few years in order to gain that kind of first-hand experience and be able to enrich the analytical abilities of the Competition Commission, which has actually been one of the good things which has happened, in spite of the fact that they can't hire from the private sector, can't hire from the market as such. I remember some of them have worked there for 6 months or 1 year and come and joined us because they could not continue after that. They have a very funny recruitment system. This is in spite of the fact that the Indian Institute of Management, which is one of our premier Indian management institutes in India, they have several of them, they did a kind of a study for the Competition Commission as to what should be the staffing pattern. And they looked at a similar regulator that we have in India called the Securities and Exchange Board of India, the primary market regulator, which has an excellent system, is able to pay a higher salary than the government and attracts good talent as well. And yet we have this oasis, which unfortunately the Competition Commission could not really get it done from the government. And there is a problem in terms of, they really are not independent of the ministry. Here in this case it is the Ministry of Corporate Affairs, which is the relevant ministry for the Competition Commission of India, which is also looks after, mainly the Corporate Affairs Ministry administers the Companies Act, which has just undergone a very major revision and is being implemented. Incidentally, as I talked just the other day, there was a very, I'm not so sure how to qualify whether it was progressive or regressive, but the Competition Appellate Tribunal has now been merged with the National Company Law Tribunal. I don't know whether it will work well or not, but there have been noises about it. You can't take away, you cannot have a generalized body to deal with a very specialized law. Let's see, I don't know what happens. There might be a problem. Now, the other challenge that I can see is the constant struggle between the judiciary and the bureaucracy, which will continue to happen. In one manner or the other, it will also affect the implementation of the Competition Act, particularly in terms of, as I said, the kind of amendment challenges which are there. I'll give you one example of overlap. Another example that we've been trying to deal with is the issue about where there is an implicit cartel and not explicit cartel. Usually you can call it collective abuse of dominance. There could be price parallelism, there could be a price leadership and so on. But you can't prove that there was a cartel. So how can we define the law, particularly under the abuse of dominance, to call it a collective abuse of dominance? Happens in many other laws, that's another very major challenge that we have to deal with. There was a very major, every time there is a shortage in a supply of a particular agricultural commodity like onions or pulses and so on, the prices have gone up very drastically, and in spite of all efforts by the government to find out whether there was an explicit cartel, they know there is no explicit cartel. It's just price leadership. There's somebody who's a big stockist or a trader would set a particular price and all the others would follow. This is the price that we'll do. So we've had these kind of problems. That is another major challenge that we see which is going to happen, which needs to be dealt with. The kind of independence which is required for the competition authority to be more effective remains a challenge with not only the Competition Commission but with other sector regulators, with all kinds of similar bodies. That comes from the kind of political economy of the country where the minister would like to continue to keep his thumb on the regulator, even if the regulator is. One day I saw the chairman of the Competition Commission sitting outside the chamber of the Minister of Corporate Affairs. So I asked him, I said, what are you doing here? You shouldn't be here. The minister's called. See, their appointments have been made under the pleasure of the minister. I don't know whether Alan, whether you ever sat outside the treasurer's chamber.
Begging, some sad appointments.
Right. No, it can happen, but generally in India it is quite. I know the chairman of Competition Commission of India was on a tour of Australia along with the minister, which the Australian government had invited them to come and see the kind of competition regime which operates, which included competition policy. As Alan said in his introduction, we were also responsible to draft a competition policy, which is by and large inspired by the Australian experience. And in that context, I've been here, including I was partially responsible to get our minister to come here, as well as who then brought along the then chairman of Competition Commission of India. Now, competition culture is expanding, in spite of whatever some people know. One of the biggest competition reforms which has just taken place is a goods and service tax, where again Alan was there recently to speak about the goods and service tax experience of Australia at a particular event in Gujarat. And so there are many of these reforms which are taking place. The competition policy which we have drafted has not yet been adopted by the government as a policy, but I think it doesn't matter. And a very important aspect of that competition policy was to do competition impact assessment. And that we've been able to get the Competition Commission of India to initiate. And we've already had a couple of rounds of trainings, etc., etc. And they have received one request recently from one of the ministries to do an impact assessment on a particular new policy that they're going to introduce. So things are happening, and I said a lot of it, particularly in the recent times, which is about in the last 10 years, we've had very good relationship at the official level and at the track 2 level with Australia. Alan has been there on our platform a number of times in India in order to talk about it, including with that. Let me thank you, and I'll be happy to take any questions.